Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a story here sent to me by a lot of people. Fascinating one, widely reported, involving our U.S. Supreme Court. This version is from Newsweek, written by Jenna Sundell. 5 Supreme Court justices sit out case in rare move. 5. So there's 9 justices on the court. And once in a while, you hear about one justice who cannot be involved in a case for whatever reason, and it could be a conflict of interest, or it could be that they were on the lower court that was being appealed and they got moved up to the Supreme Court and now the case is in front of them again, that kind of thing. But here we've got 5 Supreme Court justices going, can't get involved in this one. So the U.S. Supreme Court affirmed a lower court's dismissal of a copyright lawsuit against a writer on Monday after 5 justices recused themselves from hearing the appeal, leaving the court without a quorum. And so what normally happens is if one judge sits out, there's 8 left. Well, you can still win or lose depending on how they vote. But with only 4 left, it'd be impossible to get a majority. So they just said, we're going to let the lower court ruling stand. According to the order released on Monday, Justices Alito, Sotomayor, Gorsuch, Barrett, and Brown-Jackson did not participate in considering the petition, which effectively ends the case at the appellate level directly below them. Newsweek has contacted the Supreme Court for comment, but apparently has not gotten one. Supreme Court often acts secretively about how they do things behind closed doors. The incident marks the highest number of justices sitting out a Supreme Court case since the court adopted a formal code of conduct in 2023. With no quorum, the ruling of the lower appellate court will remain in force. And the ruling of the lower court, it rejected allegations that an author had plagiarized from another author's book. The incident has put renewed focus on judicial ethics and financial conflicts of interest, an issue under public scrutiny following recent disclosures about justices' lucrative book deals and gifts. So the rare mass recusal pretty much ends the case, which involved allegations of plagiarism, and they were against a writer and several entities connected to his book. The justices did not publicly explain their reasons for recusal. They didn't say, here's why we're doing it, but we pretty much think we do know. So Michael Gerhardt, the Burton Craig Distinguished Professor of Jurisprudence at the University of North Carolina, told Newsweek of another instance when justices' recusals left no quorum. In 1945, all the Supreme Court justices recused themselves from a case called U.S. versus Aluminum Company of America. Congress had to pass a special law that authorized the Second Circuit Court of Appeals to render a final judgment in the matter, and Judge Learned Hand wrote an opinion for the appellate court that's widely regarded as one of his best and the only opportunity he would ever have to make a decision that was considered a Supreme Court decision. If you go to law school, you read a lot about Learned Hand. He was a judge who wrote a lot of opinions that people said were beautifully written and correct, and you could study them. This professor says the public would likely not know why the justices recused themselves unless the justices chose to disclose the information. So they're going to say, we did the right thing, we recused ourselves, but we don't have to say why we did it. But this guy says it appears the justices had recused themselves because they had book deals with the same publisher as one involved in the current case before the court. A party in this case owns Penguin Random House, which has published or plans to publish books by at least 4 of the justices. That would explain a lot. Alito, whose published works have not been associated with Penguin Random House, also recused himself from the proceeding. And he may have just done that because he thought, hey, it's too close to what I have worked with. I don't know. This case began with an author filing a suit back in 2022 alleging that a book had plagiarized content from his book, and a federal district court dismissed the case, and the dismissal was upheld on appeal. The courts found that the works had little in common except broad subject matter. Now, despite the Supreme Court's adoption of a formal ethics code in 2023, many advocacy groups have called for further reforms, such as mandated transparency about justices' reasons for withdrawal and stronger enforcement mechanisms. The current code encourages recusal in the case of direct financial interest, but does not compel them to do that. So a couple of things we should look at here, and one of them is the idea that somebody wrote something in a book and that somebody else wrote something similar to it in a book is not necessarily illegal, but these allegations get raised all the time. So if you're familiar with the Da Vinci Code, written by Dan Brown, made into a movie with Tom Hanks, you know that the whole plot turns on the idea that the Holy Grail might not have been a thing you drink out of. It may have been more metaphorical about the bloodline of Christ. And it turns out that Dan Brown didn't invent that idea. Several other authors had written books suggesting that. And there were a couple authors who wrote books suggesting that had a lot of similarities to the Da Vinci Code. And I know at least one lawsuit was filed, possibly two, saying that the ideas in the Da Vinci Code had been taken from these other sources. But of course, the ideas are not things that you can copyright the same way you can copyright the words and phrases and paragraphs and so on. And so that usually is not enough. And don't get me wrong. If someone takes, and I'm not saying that Dan Brown did this, but I'm saying if someone takes wholesale an idea from one book and just calls it their own, I do think that's not good. I'm not crazy about that idea. But you know, there are ideas out there that have been kicking around for a while that a lot of people have heard of and thought about. And, you know, the idea, you know, all the spin-offs of vampire slayers. I don't know if Joss Whedon would be running around chasing those people down saying, hey, that was my idea. I'm not sure if he was the first one to come up with Vampire Slayer, although Buffy was iconic. I will also tell you that, full disclosure, I've written a book that's published by Penguin. See, there's a little penguin right there. And so my book, American Murder Houses, was published by one of the parties in this case. So I'm just disclosing that so we have full disclosure. But I can also tell you that plagiarism is one of these things that people hear about, especially if you're talking about, you know, academic honesty. But plagiarism does not necessarily rise to the level of copyright infringement. And so there is an area out there where people can get in trouble for stealing the work of others, but they can't necessarily get sued successfully because it might not rise to the level of copyright infringement. So I can tell you that I've written things that were plagiarized by others. And I pointed this out to publishers and said, hey, by the way, you just published something that was lifted from something I wrote. And I've had a publisher go, okay, well, what are you going to do, sue us? Well, I can't sue them because it wasn't that specifically a copyright infringement, but it's clearly something that someone stole from me. I've also had something of mine plagiarized, very, very painfully and obviously, and that was published in a book, and it was published by a publisher, but the book was written by a professor who plagiarized my work, and I sent a note to the university where that professor taught, and I said, hey, just to let you know, a professor who works for you plagiarized something I wrote. Here's what I wrote. Here's what was published by the professor. And they wrote me back and they said, well, we have taken steps, but we can't tell you what they are. And I said, why not? And they said, well, it's confidential. Did they do anything? I don't know. But I assure you that if somebody had handed in a paper in her class and had lifted things from another source and stuck them in there and claimed them as their own, she would have given them a 0 on the assignment and possibly kicked them out of school or gotten them kicked out of school for violation of the academic honesty policies. You can actually be expelled for that. And so, interestingly, the rules at that university actually said that the academic honesty policies actually apply to everyone, not just students. It also applies to faculty. And so I was really surprised that that happened because I thought to myself, you know, if you're standing in front of a classroom lecturing them about how to do a well-written assignment and where you follow all the rules, and then you publish a book that's got plagiarized stuff in it, it kind of hurts your credibility, doesn't it? Doesn't it? But what are you going to do? What are you going to do? So back to this case, 5 Supreme Court justices sat the case out. And this is an example why I am a big believer that it ought to be wrong for somebody who's sitting on the Supreme Court to be given a book deal, especially one with a gigantic cash advance, as many of them are. I think they should wait till they retire to do that because of the fact that it can create a conflict of interest. Now, if I told you this story a month ago and I simply said, I think that the Supreme Court justices shouldn't get book deals because it could create a conflict of interest, You'd say, what are the odds of that happening? Here the odds are. 5 Supreme Court justices had to sit the case out because they all had conflicts. And we're reasonably certain that 4 of them had conflicts because they have book deals. The 5th one, don't know for certain, but we're starting to wonder, okay? So that's what can happen. At the very least, this can happen. That's a problem. But I'd also worry that if a publisher came along and gave somebody a gigantic book deal advance, I'd worry about that simply because of the fact that money often does affect people's emotions and how they think about things. And it is it's called a poorly kept secret that some book deals are given out as favors. And if you don't believe me, just look around once in a while and you hear that somebody got a $10 million book deal and you're like, who's going to read that? Who's going to read that book? And there have been some clunkers. There have been some absolute clunkers that have been published where the book, instead of launching, literally just when it came out. And some publisher lost millions and millions of dollars on the advance and printing up these things and then pulping them and then hauling them off to the dump. But why'd they do it? Well, because they were returning a favor for somebody. And so what can I tell you? But everybody sent us thanks a lot from Newsweek, and Jenna Sundell wrote that. 5 Supreme Court justices had to sit out a case in a rare move, the result of which meant that they can't hear the case and no one else can. Therefore, the case ends one step before it ought to have. There you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
Live your life by a compass, not a clock.